Welcome to the June 22nd, 2022 Standard of Care Ad Hoc Committee. My name is Sang-Oh, Chairperson of the committee. Before we convene, I'd like to remind everyone present that the board is a consumer protection agency charged with administering and enforcing pharmacy law. Where protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. Today, our committee will continue our education on the issue and will begin considering some high-level policy questions. This is a very complicated issue. As we proceed today, I urge caution that we do not too quickly rush to decisions or conclusions. This meeting is being conducted in a hybrid fashion. As included on the agenda, members are participating at a public location in Sacramento. Members of the public may participate in person at the Sacramento location or via Webex using the link provided on the agenda. Participants watching the webcast will only be able to observe the meeting. Information and instructions are posted on our website to join the Webex as well as the webcast. As I facilitate this meeting, I will announce when we are accepting public comment. I have advised the meeting moderator to allot 2 minutes to each individual providing comments. As public comments are taken, I intend to first accept public comment from those individuals attending in person, followed by those individuals participating via Webex. Throughout the meeting, there are a number of opportunities to provide comments. Also, as included in the meeting materials, there are a number of policy questions we hope to discuss today. For purposes of public comment during the portion of the meeting, I intend to open a question to committee members for discussion. Following committee discussion on the specific question, I will then open up for public comment on that specific question. We will be allocating 3 minutes to each stakeholder wishing to provide comments. We will follow this same process for each question posed. I will note that this is the first of several meetings where policy questions will most likely be considered. All such questions are intended to assist the committee and board to reach recommendations to offer the legislature as required by AB 1533. I also want to note that due to some time constraints, we are unable to complete all of the policy questions today. We will resume consideration of questions at subsequent meetings. Having covered the process I intend to use to facilitate the meeting today, I'd like to ask staff moderating the meeting to provide general instructions to members of the public participating via Webex. Tricia?
Thank you, Mr. Chair. Before we get started, I would like to remind committee members and staff who are not speaking to mute their microphones during today's meeting. If background noise is detected as a result of unmuted microphones, I will mute those microphones. There are members of the public in the audience and meeting minutes are being taken, so we ask members and staff to please identify yourselves before speaking. For purposes of today's meeting, when the committee chair opens public comment, members of the public who would like to provide public comment at our DCA headquarters location in Sacramento can approach the table and microphone at the front of the room. For those joining us on Webex, we will be utilizing the Webex question and answer and hand raise features to facilitate public comment. When public comment is called, I will open the question and answer feature, which you will hear me refer to as the Q&A, and members of the public who wish to make comment can click on the Q&A icon, type the word comment in the text box, and click on the send button. To utilize the hand raise feature, simply click on the hand icon next to your name and raise your lower hand. Those who have called into the meeting can dial *3 to raise and lower their hand. These instructions will be displayed on the screen during public comment. After we have taken public comment from our Sacramento location, I will call on those individuals requesting to comment through Webex. And I now return the floor back to you, Mr. Chair.
Thank you, Tricia. All right, I would like to take a roll call to establish a quorum. Members, as I call your name, please remember to open your line before speaking. Maria Serpa.
Licensee member present.
Thank you, Maria. Indira Cameron Banks.
Public member present.
Thank you, Indira. Jesse Crowley.
Licensee member present.
Thank you, Jesse. And Nicole is not here, so I am here. The quorum is established. I'll now open the meeting for public comments for items not on the agenda. I'd like to remind members of the public that you are not required to identify yourself, but may do so. I'd also like to remind everyone that the committee cannot take action on these items except to decide whether to place an item on a future agenda. Members, following review of the public comments for this agenda item, I will ask members to comment on what, if any, items should be placed on a future agenda. As a reminder, this agenda item is not intended to be a discussion, rather an opportunity for members of the committee and members of the public to request consideration of an item for future placement on an agenda, at which time discussion may occur. I will first open up to public comments for individuals attending in person. Seeing none, moderator, we are ready for public comment for Webex.
Thank you, Mr. Chair. I've opened up the Q&A panel. If any member of the public would like to make comment, please type comment using the field in the lower right-hand corner of your screen and submit it to all panelists, or you may simply raise your hand. We'll give you a moment. All right, this is a moderator. I see no request for comment at this time. Shall I close the Q&A panel?
Yes, please. Thank you.
You're welcome.
Moving on to agenda item 3, approval of the March 9th, 2022 minutes. Attachment 1 includes a copy of the draft minutes from the March 9th, 2022 meeting. As we begin, I will first ask for questions or comments on the draft minutes from the March 9th, 2022 meeting. I would also entertain a motion if you believe such action is appropriate. Members?
President, this is Eileen Smiley, Board Counsel. I just had 2 comments I wanted to make on the minutes to draw to the board's attention. When we're talking about the legislative mandate, and this is on page 2, 3rd paragraph, what we're supposed to prepare a report on is implementing a standard of care enforcement model for pharmacy law. So I'd like to insert enforcement before model, and the same thing on page 4, the second full paragraph.
Okay. Anyone want to make a motion with the amendment our counsel suggested?
Hi, this is Maria Serpa. I move that the minutes be approved with the changes suggested.
Thank you. Anyone second?
Indira Cameron, I second.
Thank you, Indira. Okay, with a motion and second, and we'll open up for any other comments? No? Okay. We'll open up for public comment in Sacramento and public comment in Webex. Tricia?
All right. I wasn't sure if there was anyone at your location. Thank you. So I have opened up the Q&A panel. If any member of the public in Webex would like to make a comment, please type comment using the field in the lower right-hand corner of your screen, or you may simply raise your hand. We are displaying instructions and we'll give you a moment. All right. I see no request for comment. Shall I close the Q&A panel?
Yes, please. Thank you.
You're welcome.
With a motion and motion and second and public comment, we'll take a vote. Maria?
Yes.
Thank you, Maria. Indira?
Yes.
Thank you, Indira. Jesse?
Yes.
Thank you, Jesse. And I vote yes, the motion passes. All right, moving on to the next agenda item 4, presentation by Carrie Webb, Counsel, Medical Board of California, perspective on standard of care enforcement model in the practice of medicine. Members, I'd like to welcome Carrie Webb to our meeting. As a counsel for the Medical Board, Ms. Webb is well positioned to provide members with education on the standard of care model used in the practice of medicine. Ms. Webb, are you ready for a presentation?
I am. Can you hear me okay?
All right. Excellent. Yes, we can. Thank you so much.
Very
The
good.
floor is yours.
Okay. Thank you so much for having me and to Anne for inviting me. I am Carrie Webb, Staff Counsel to the Medical Board of California. I've been their Staff Counsel for over 9 years, and prior to that, I was a civil litigator for over 12 years, prosecuting medical malpractice cases and other types of personal injury cases, all of which required delving into the standard of care to prove the case. Disclaimer, this is my presentation to you. It reflects my personal observations as being counsel, so it's not a something that the board is presenting to you, but I'm doing it as their staff counsel. There will be some brief overlap with some of the information that you've already received from your staff counsel and the DAGs that presented before. I thought they did a great job, but we'll just set the stage. Next slide, please. Oh. On my view, it's sideways. Is that? Do you guys see the slide? Does it appear sideways to you?
Yeah,
Yes,
it is
this,
sideways.
if the co-moderator could go up to view and choose rotate right, that'll take care of it. There you go. Thank you.
Okay. So this is the code section in the Medical Practice Act that authorizes the board to take action for unprofessional conduct, which includes any violation of the Medical Practice Act, gross negligence, repeated negligent acts, and incompetence, among other violations. Next slide, please. The standard of care basically comes down to what would a reasonably careful and prudent physician do under same or similar circumstances at the time the care was provided. And that factor is key because sometimes cases go to hearing many years after the actual event that is being prosecuted. And so it's not the standard of care at the time the matter goes to hearing, but rather the standard of care that was in place at the time the care was provided. And how do we know what the standard of care is? That must be established through expert testimony. And if you've reviewed transcripts, you'll know that when an expert testifies at hearing, the Deputy Attorney General or DAG starts the direct by having the expert walk through their training, experience, publications, presentations, accomplishments, and awards to show the administrative law judge that they can credibly testify on the standard of care. Next slide, please. Positives with the standard of care enforcement model is that it's flexible. It depends on the facts and circumstances. It factors in the location where the treatment occurred, such as in an ER versus it being a planned procedure in non-emergency situations. It also factors in such things as the physician's history with the patient, whether the patient's a reliable historian, whether the patient's compliant, and also whether we're in a state of emergency. So there doesn't have to be a lot of detail in the law because the facts and circumstances are factored in at the time that the event occurs. It changes over time without the need for statutory or regulatory changes. And it recognizes that the law cannot possibly cover every scenario. The standard of care controls most interactions. Next slide, please. That being said, there is something important that's in the Medical Practice Act, and that is there is a ban on the corporate practice of medicine. And my understanding is that does not exist in the Pharmacy Practice Act. What this means is that the standard of care has to be set by licensees, not lay individuals or corporations. This is important because licensees put their license at stake in their decisions. and they are obligated to put patient safety above profits and other interests. The standard of care must control over policies and procedures that require conduct below the standard of care. And if you've got lay individuals or corporations trying to set this, you can risk patient protection. So this ban on corporate practice must be given due consideration if you are contemplating switching to a standard of care enforcement model. Next slide, please. There are some challenges with the standard of care enforcement model that you need to be aware of. There's very few bright line rules in the Medical Practice Act, and this can be frustrating for licensees who, most of them, want to know they are doing the right thing. They want to know what's expected. They want to know how to avoid coming to the attention of their licensing board. They don't have to know as many laws, but they have to know the standard of care for all of the care and treatment that they provide. And sometimes the board is contacted by licensees who are asking for advice on how to handle certain situations. And the staff tells them it depends on the standard of care. You have to follow the standard of care. If they don't know what that is, they have to research it. And but we can't tell them. There's no code section to point to that this is what you do in this situation. There's your prior presenters from your last meeting brought up that this means the outcome can depend on the winner of the battle of the experts. The board will have its expert or experts, and defense will have theirs. But defense has a bigger expert pool, in part because they set their own limit as to what they will pay. A lot of our respondent licensees are very well funded, and so they can pay a high cost for the expert of their choice. But the board can only pay very little. And so the board depends on, it's virtually volunteer work because the board pays $150 an hour for all the tasks, $200 for testimony, unless the expert goes to expert training provided by the board, and then they get a $50 an hour increase to that, up to $2,000 a day for testimony. But if anyone has familiarity with litigation, this is a very, very low rate of pay. It was nothing to be expected to pay $10,000 for a day of testimony when I was in private practice. So this can set up a challenge, although we have many great experts that do it for the good of the profession. And that's what it comes down to. So this last point is a big one that sticks with me, and that is the standard of care does not have to be the best care. So when the expert testifies, they have to it's not what they would do, because maybe they strive to provide the best care, but rather what the community standard of care is. And so if there's something that you want licensees to do and you want to make sure they do it, this might not be covered by the standard of care. An example is the requirement to check cures for physicians. That is something that's specifically required in law if they're going to prescribe levels 2 through 4. They have to check cures first. That prior to that being a requirement, some physicians did it, but it was placed into law so that that's become part of the standard of care because it's required by law, not because the community as a whole was doing it. Next slide, please. So when you are contemplating switching to a standard of care enforcement model, you have to be prepared to work with experts, and there's a number of challenges involved with this. Finding the right person, the training that's involved. The board provides all-day trainings several times a year. The monitoring, meaning you have to make sure that there are no pending issues, no pending complaints, and that they're being responsive to reviewing the records and getting reports back to you in a timely manner, and that when they sign on to this, they have to be agreeable to going to hearing. And sometimes there are experts who they know most cases settle and they're reliant on that, but they really don't want to go to hearing. They have to be prepared, though, to go to hearing. That takes time and money because you're paying for the DAG to do that. You have to pay for their time, and then making sure that they felt that they were well prepared for the experience, for the cross-examination, because you want to retain the good experts. It can be a very difficult and sometimes defeating experience to go through cross-examination if they're not well prepared. So a lot goes into that. And then be prepared to defend them from lawsuits by disgruntled licensees after the fact. So the Medical Practice Act has a code section that provides for that, and it does happen. Next slide, please. And with that, I'm happy to take any questions.
Thank you so much, Carrie. I really appreciate your presentation. I think it underscores there may be some key differences between regulation of medicine and the regulation of pharmacy, including a prohibition on the corporate practice of medicine. As we continue our discussion today, I believe it is imperative that we remain mindful of these types of differences. I'm sure we have members with some questions. Any questions for our council? I have a few as well, but go ahead.
Hi, thank you for your presentation. This is Maria Serpa. I think some very interesting new information to me, especially regarding the use of expert witnesses and having to have a very prolonged process, it appears, for evaluating some disciplinary issues in some situations. In your experience, what's the volume that you anticipate our board may be looking at requiring these extended disciplinary hearings versus the number? Is there like a percentage that we could kind of estimate? I just don't know. I know it's not all disciplinary issues are going to go to this extent, but if you could help us figure out volume going forward.
Well, I mean, we get over.
I think you're. Oh,
can you hear me? Okay.
Yeah.
The medical board gets over 10,000 complaints a year and takes action on, very small percentage of that, probably 3 to 4%,
How many number of cases was that, Ms. Webb? Or
Get 10,000 more than 10,000 complaints a year.
okay.
Okay.
But the percentage of discipline is like 3 to 4%. I don't know how that compares to pharmacy board.
So I guess another question then would be, just to clarify for me, of those 3 to 4% that go on to discipline, do all of them require these extended process with expert testimony, or is that
No.
a subset?
Because, I mean, all of them, virtually all of them require an expert report because that sets forth the basis for the accusation. But probably 80% or more cases settle with a stipulation rather than going to hearing.
And I guess, is it appropriate to ask staff a question? So I'm trying to get apples in here instead of just all these apples and oranges. The number of complaints that the board receives and how many of those go on to discipline, or what percent? Do you have an idea? I know I'm kind of asking the question out of the blue, or maybe you can get that information to us later.
Yeah, I'd be happy to get the information for you later. So one of the dynamics that I'm not quite sure the medical board has, but we definitely have, is that we typically have multiple respondents in a case. So we may have a single investigation, but we are investigating multiple individuals. And so that's a different kind of dynamic than maybe medical board. I'm not quite sure how Carrie feels about that. But so I think the approach and the impact may be a little bit different just because of that, because of how we regulate and the types of entities, because we do the business, the product, and the people, right? So that, I think, is one potential difference that we need to consider when we're looking at this. Is we can look at how so many different people have approached this issue and, you know, how their landscapes work. And then understanding all of those, we're going to have to sometimes kind of project a little bit and kind of guess on what that would look like.
Thank you. Yeah, that's where I think I'm having a problem. Even at our last meeting that we had, our first meeting, is projecting and estimating and using the background information, which is really apples and oranges, and how to project that for us. So thank you.
Ms. Webb,
Thank you for answering the question.
just to piggyback on that a little bit, if for medical boards, are the enforcements usually driven by complaints, or are they all really driven by complaints? Or are there ever a routine inspection? I mean, I think that's probably just us. We do that.
It is mostly complaint driven.
Okay.
There are some proactive projects that we have, including the prescription review project, where the board gets death certificates from the Department of Public Health that where the death was related to a prescription overdose, and then runs cures on those, and does an evaluation on whether the physician needs further investigation for potentially excessive or inappropriate prescribing.
But that requires literally a person dying for you guys to actually investigate. Wow, okay.
Well,
all right.
I mean, I can't let that just lie right there. That's that particular project.
Okay.
Otherwise, as I stated earlier, the board receives over 10,000 complaints.
Right.
A year.
Okay. And go ahead.
Good morning, Ms. Webb. Thank you for that presentation. I wanted to just flesh out a little bit what the sort of battle of the experts looks like in the enforcement process. And so let me start with a couple sort of premises. So first, if there is, it seems like, is it true that there are two different wells of experts that you're finding, sort of repeat experts that you guys use and that the licensees use over and over? Is that something that you find to happen? Is there consistency with respect to who the experts are?
I think sometimes that does happen, but for the board, even for defense, but for any litigator, if you're using the same experts over and over again, you're subjecting them to cross-examination with impeachment if they're not very, very careful. And so the board actually looks for experts that have testified for both defense and plaintiffs in like med mal cases, or for respondent physicians, as well as the board in administrative cases, because it shows that they testify based on what they believe is accurate, and that they're not only beholden to one side. So it tends to show that, give them more respect, more credibility if they have testified for both sides.
And so then in a particular case between the experts, I guess the expectation is there'll be some overlap with respect to their opinions as to what the standard of care is. Considering if the standard of care is sort of a band between what is the best in that scenario and what is the least but most acceptable practice in a specific scenario and set of facts, the expectation is that there would be crossover, right, between the different experts, right?
Yeah.
Okay.
What sometimes happens is that an expert, well, for the medical board, would maybe describe something as an extreme departure from the standard of care. Well, that's gross negligence. That's a want of even scant care. And the respondent expert will say, well, yeah, he should have done better. She should have done better in this particular instance, but it's a simple departure. It's a negligent act, not gross negligence. And then it comes down to the administrative law judge, who's not a physician, determining which expert has more credibility. And sometimes, this comes down to, does the person concede a point that should be conceded during their testimony, or do they take an unreasonable position on something that just seems so obvious to everyone else in the room? Really how they conduct themselves. Are they an advocate for one side or the other versus this is the standard of care in the community? Maybe complainant sees it as a extreme departure, but it's not. It's a simple departure. And so the ALJ is evaluating their body language, their tone, their willingness to concede points that should be conceded, and not take unreasonable positions. And then, from that, making a credibility finding to decide which expert was more credible. And sometimes the expert's more credible on this point, but the other expert is more credible on the next point. So it can go back and forth depending on the situation.
So then, to clarify, is the experts really battling about how far of a departure below the standard of care a particular licensee has acted?
Sometimes, and sometimes it's that this person didn't commit a violation at all.
Okay.
And it's there's not always agreement. Whereas if you have a law that's straightforward that says you must do this, one of our newer laws related to prescribing to youth is that you must give informed consent that addresses these issues to the youth's parent or guardian, right? That's specifically in statute. Otherwise, informed consent is a matter of standard of care. They have to obtain it, but what's included in it, that can come down to what is expected in the profession.
All right, last question. Sorry to monopolize. How,
okay.
with respect to the stipulated settlements, sort of resolutions, how often do you find it's dependent on the credibility of the experts or how they've performed?
Yeah.
How much does that affect the dynamic in a stipulated settlement?
That's huge, but it's not how they performed at a hearing, because our stipulated settlements occur before it goes to hearing. It may happen like after a first day of testimony, but I can't think of an example. But it is a big deal. So, with our DAG memos that go to board members explaining the recommendation, a lot of times it does come down to expert credibility when faced with, our experts write the report, that's exchanged in discovery, then the respondent physician can obtain their expert, and their expert has the benefit of all the evidence of the board's case, including the board's expert opinion, and they write their expert opinion, and that's shared with the board's expert, who then may recognize, I've missed this, I've missed that I can see that's a different way of interpreting this, and then they can alter what their testimony will be at hearing, and that can influence the strength of the case. So that gets factored into the recommendation for a stipulated settlement. Or the expert could say, I'm not going to testify now. And again, that obviously influences the strength of the board's case. So a lot of our stipulations have to do with what is likely to occur at hearing, and whether a 3-year probationary period, for example, makes sense, so that we know discipline is imposed now that cannot be challenged, versus go into hearing with the hope of getting a 5-year probation. It's all that is factored in, and experts play a big role in whether something settles and for what level.
Are you good, Indira?
Yeah, thank you.
Yeah, Jesse?
Thank you so much for presenting today. You've given us a lot of information. I do have a few questions for you. So you did give us an example of physicians being required to use cures for prescribing controlled substances, and how that regulation needed to be adapted because it really wasn't required under the standard of care model. So my question is, how often does the medical board have to adapt and implement new regulations to supplement for some gaps under the standard of care model?
I don't think it happens very often. This is just my anecdotal sense after 9 years of experience, where there's a requirement like that imposed. But more recently in the prescribing arena, that's where I have seen it. Also, like in posting signs for stem cell treatment to notify patients that if they're providing care that's not FDA approved. But I don't think this happens very often.
Great, thank you.
And again, what that means is that there may be something you want licensees to do because that would provide better care, but it's not a requirement in the standard of care. It may be a best practice, but it's
Okay.
it's not required by the standard of care. It's above it.
My next question is just knowing that the medical board and the nursing board both operate under a standard of care model, have you had scenarios in which standard of care models across practices have contradicted themselves, or where you've run into issues with that?
I can't think of an example. It's an interesting question, though. I'm not sure that would happen.
Great. Yeah, I just think of it, just kind of reviewing some of the materials from the Idaho board. They allow some pharmacists, for example, to change medication regimens or add on. An example would be a statin for patients with diabetes without having to consult the physician. So I envision a scenario in which that could be an issue, at least for the pharmacy board to physician boards. I was just curious if you've had that in your experience for nursing versus physicians.
I can't think of an example.
And then the last question I have for you is just kind of getting into the impact on the board to protect experts long term. I imagine there's probably a substantial financial impact where, we may have to deal with the lawsuits against the experts from, as you said, disgruntled licensees. What does that look like exactly? And is it the sort of scenario where the board would then have to testify on behalf of that expert in defense of them?
Well, if it gets that far, then there could be discovery. So that could entail interrogatories, requests for production, depositions, and then ultimately a trial if it gets that far. A lot early with a demur or request for dismissal. Some of them have to go forward to a motion for summary judgment, which would occur later after a period of discovery. But even if it's disposed of early, it's expensive. And it's expensive even though, fortunately we have the Attorney General's office whose rate is much less than in private practice. But it's still, they have to be very careful. They're very conscientious in their efforts to protect the boards and the experts. But, we have a case right now where the person accepted a stipulated probation, and then it's like 12 years later naming all the board members and the expert witnesses, and we have to go through the process to dismiss it. So it just takes time and money, and it's part of what comes with the territory with the standard of care enforcement model.
Great, thank you.
Hi, Carrie. This is Eileen Smiley. I'm board counsel, and I just had a couple of questions for you. You had mentioned that with the standard of care, obviously the standard of care can change, vis-a-vis, different settings, like somebody coming in to an emergency room versus a
Eileen,
planned.
does anyone else hear like an echo?
My microphone's on. Is this one? No. Okay. Is it still there?
Yeah, I hadn't noticed it until you started talking, so I don't know if it's that microphone.
Could be that. Is this better? No.
No.
Okay, how about if I'm going to write out two questions and have somebody else answer them.
Okay.
Is this happening here as well?
I hear it now too.
Yeah, it's probably the system. So I don't want to cut this short because this is so important.
They're all microphones. Okay, they're all. So the first question was, you had talked about that standard of care can vary if it's provided, say, in an emergency room versus, say, a planned procedure, because that's taking into account the circumstances under which the practitioner is operating. Under the Medical Practice Act, your standard of care, are there variances depending on location within California? Like, for instance, could standard of care be different, say, in a rural area of California versus, say, San Francisco, Los Angeles?
Yeah, I think I was able to make that out, and yes. So if the respondent physician practices in a rural setting, then an expert who's from, LA or San Francisco, maybe a big UC hospital, if they don't have experience practicing in a rural setting, that would be a way to impeach them on cross-examination, because the tools and the resources that they have available, the ability to have a specialist consult on a matter, the ability to refer someone within a short time frame in the locality for specialist treatment is very different than in rural settings. And so that definitely plays a role in who the experts are, because they have to be familiar with the standard of care for that setting and that location, to be credible.
Thank you. And the second question I had about helping or retaining your experts, as part of the retention of experts, does the medical board have to agree, like to indemnify them or to come to their defense, or how is that handled in the contract, or is that just something that the medical board may be subpoenaed by disgruntled, say, licensee?
Eileen, can you start again? The
Sure.
echo has disappeared, but I missed that first part of the question. I'm sorry.
Okay, so when the board retains an expert, and there could be a lawsuit after, are there any contractual provisions you have to sign or that are included within the retention agreement that obligates the medical board to maybe come to the defense of the expert if they're sued by a licensee?
It's in our code that we do that. I'm not sure if it's in the contract. I haven't reviewed it recently, but it's on our website for our expert reviewer program that we provide defense in those situations.
Okay, thank you.
Yeah, and we do have we have an expert program page on our website. We have a brochure too that you may be interested in seeing.
So, Ms. Webb, sorry, I'm just on about the expert witnesses. Like, I'm just thinking, and I would imagine there's probably a case going on right now. So if you say you can't tell us, it's understandable. But like, thinking about some cases, like I can think of COVID cases that you probably have going on. And from what I've read and studied, I mean, there's a lot of times you can find a physician who would be willing to say something that may not be very standard to what is a very standard treatment, but there are physicians you can find that will say, and they believe, and they have their studies to demonstrate what they think. So when there's a contrary like that, which I'm sure you face all the time, I would imagine, unless it's a very clear negligence case where the doctor just did not do something like testing a lab. If there is a difference of a treatment modality or what kind of actions to take, how do you reconcile that?
Well, the board has to prove its case by clear and convincing evidence to a reasonable degree of certainty. And so that is ferreted out at hearing if it's not resolved via stipulation. And the ALJ has to make the call. And if the board did not prove its case by clear and convincing evidence, then the board loses that case and the accusation is dismissed. So, you know, that does happen from time to time, and never a comfortable situation, but it's the reality of our enforcement process that it does happen.
Okay, and how about, I'm not familiar with physician practices and their policies and procedures. I'm not familiar with their agreements and their, agreements in like their professional corporation practices and whatnot. I'm not an expert, but have you come across a situation where the physician group may have a policy and procedures and the standard of care may have been impacted by the policies and procedures, if any, if there is? And I think from your slides, physician practices may not be allowed to have policies and procedure dictate the standard of care, but if you could just elaborate on that, if you come across any situations with a conflict of policies and procedures with physician practices and their groups.
Physician practices do have policies and procedures, but they can't have them set to be below the standard of care. And so a lot of times you'll see cases where as part of their mitigation package, evidence of rehabilitation, they say, I've changed my policies and procedures in my practice to do X, Y, and Z. An example of a recent case is urgent care physician who failed to document repeat vitals. And it should have been done. The medical assistant, he said, didn't do it, but the physician's responsible for that. And so the physician went through and updated their policies and procedures so that there's safeguards in place, did additional training with staff and physicians, and then showed evidence that the practice had been updated, and that tells the board that this person is capable of being rehabilitated. I don't know what's in the Pharmacy Practice Act, but the Board Practice Act Medical Board Practice Act has a requirement that public protection is paramount. But the board needs to take action to rehabilitate the physician unless the efforts to rehabilitate the physician is contradicted by the need for public protection. So if someone is showing you that they will adjust their behavior for patient protection, they're showing you, I'm willing to be rehabilitated, I will take the board's direction on this, you don't have to revoke my license. So when there's a case like this where an expert points out a deficiency, many physicians update their policies and procedures as evidence of rehabilitation in their case.
Okay. Okay. Thank you, Ms. Webb. I hope you can stay throughout our meeting. And do you have a question? Yeah, go ahead.
Thank you so much, Carrie, for presenting today. Super helpful information. I'm going to ask you a question, and if you can't respond, that's totally fine. But I was just curious, in your opinion, do you believe that a standard of care could potentially delay consumer protection? When you were talking about, the different experts and the reports and how you're kind of reliant maybe on responsiveness and all of that, I'm curious to know and it might be that that process is super streamlined and so you're actually effectuating consumer protection more quickly. But when we look at, investigation timeframes and then timeframes for, to secure discipline, I was just curious if you think that the standard of care model plays into that at all. I don't know if that question made sense, but I'm hopeful that you got my concept at least.
Yeah. Boy, I wish our timelines were better. So our enforcement cases seem to take about 3 years to get through the process from complaint to final decision. And part of that, especially if it's an obscure matter, finding the appropriate expert can take time. And then if they are not responsive, we hope that they review cases within 30 days. But that's part of the monitoring, is keeping in touch, making sure that they're getting through the materials and providing a report that meets the requirements. And sometimes there's back and forth, and all of that comes into evidence. So if they have to do a supplemental report, their original report comes into evidence, and you can see that depending on the situation, it can start weakening a case, and it takes time. And if they have to be available for hearing, so coordinating that time can be an issue. But the board has to evaluate the experts, and so if they are not timely, if they balk at testifying, then that's someone who needs additional training and may have to come off the expert reviewer program. So can it add time to the enforcement process? Yeah.
Thank you, Ms. Webb. I really do hope you can stay for our policy discussion as well. I have a feeling there will be a time for us to ask you more questions as we discuss further into the policy questions today. So hoping you can stay. Really, really appreciate your presentation and your time. And as you are aware, as required by law, members of the public are also provided with an opportunity to provide comments on each agenda item. So if it's okay with you, I will open for public comment for individuals in Sacramento. I don't see anyone here. So Tricia, if you could open up Webex.
Thank you, Mr. Chair. I've opened up the Q&A panel. If any member of the public would like to make comment, please type comment using the field in the lower right-hand corner of your screen and submit it to all panelists, or you may simply raise your hand. We are displaying instructions and we'll give you a moment. All right, we do have a couple of requests. Hold on a moment. Our first request is from Daniel Robinson. And just a reminder, for the sake of time, you are limited to 2 minutes. I'll give you a 10-second warning. And Daniel Robinson, you should be able to unmute yourself. And you're unmuted.
I thought that was an excellent presentation and great discussion. I do have a question about sort of the locality rules and geographic differences in standard of care. I believe when we had a presentation originally by someone from the Attorney General's office, they did say that someone who is in a rural setting, remote, you know, it would be difficult for the board. That's one of the complications, is that standard of care is different depending on where you practice. But standard of care has been around for a very long time for the practice of medicine. And certainly there were times when there weren't computers and there weren't good ways of communicating, you know, across state lines and things of that sort. And but with all of our, you know, our means of communication and the importance of maintaining currency with practice, I just wonder if someone who lives in Barstow should expect a lower standard of care than someone who lives in Santa Monica as a patient, fully understanding that they don't have all the resources, but you know, available to them, and the experts and the consultation. But I'm just wondering if it really is, if it's where you're located. I think that if you were in a retirement community with all retired physicians who weren't keeping current, then it would be a very bad thing if we used the standard of care in that area as a guide to how to provide effective patient care. So I'd be just interested in your comment on that. Thank you.
All right, our next request for public comment is from, Stephen Gray. So Stephen Gray, I'll let you know when you can unmute yourself. And Stephen Gray, you should be able to unmute yourself. And you're unmuted.
Can you hear me now?
Yes.
Thank you very much. Excellent presentation, Carrie, and thank you very much. A couple of quick points. One of the things I want to point out is that one of the statutes that should be considered is BPC 4036, the definition of a pharmacist. And I think that has to be kind of fundamental to the discussion. Previous Board of Pharmacy Council, going back, said, read that as the statute defined, but really only allowed. In other words, if it wasn't allowed in the statute, then the pharmacist couldn't do it, which they said was completely different than what was happening for the medical board. So I would like to look at that. There's been several comments using the word liability, and I'd point out that that's confusing if we don't define which type of liability. Not you, Carrie, but in some of the other questions. You were talking about administrative liability, which is the medical board. There's also civil liability. And so it would be helpful if during our discussions we could clarify which ones we're concerned about and which ones we're talking about. And then another big difference, Carrie, is that the Board of Pharmacy, all of the inspectors are pharmacists. They're licensed members of the pharmacist profession. And that, my understanding, that's not true for the medical board. The inspectors are not physicians. And therefore, the need for expert reports when you investigate and all of that is significantly different. And I would appreciate it if you could comment on, you know, what difference that makes or may make for pharmacy versus the medical board. And then lastly, are there any situations in which the medical board licenses facilities or actions that are not of a person? I don't
10
recall
seconds.
many, if any, but could you comment on that, please?
All right, and our next request for comment is from Michael Matz. Michael, you should be able to unmute yourself. There you go. Michael, you're unmuted.
Really very interesting presentation. And this probably is something that we can't answer this morning, but is there any estimate on what it costs to set up standard of care and to administrate such a what seems to be a whole subset of the medical board, because there has to wait. You need to set up. You need the law, then you need the rules, then you need the experts and train people. And any idea what or maybe what it costs to do one case over a 3-year period, utilizing all the experts and standard of care? And I know it can vary so much, but is there any idea?
All right, this is the moderator, and that's the last of our requests for public comment. Mr. Chair, shall I close the Q&A panel?
Yes, please. Thank you. Thank you for
You're
the
welcome.
presentation, Ms. Webb. I really appreciate it. And hopefully you can stay around to have some further discussion during the policy questions. And we really, really appreciate your time today. Okay, so we're going to move on to the next agenda item 5, discussion and consideration of actions taken by other state boards of pharmacy related to standard of care. As you may recall, during our last meeting, comments were received regarding efforts undertaken by Idaho and Washington. The meeting materials provide summary information as well as links to provisions of their respective laws. Further published articles and other publicly available information was provided by board staff. The meeting materials also include articles provided as requested by stakeholders. I am hopeful you had an opportunity to review the information, which is quite extensive. You will note that the meeting materials highlight authorities provided to pharmacists. Where pharmacists in California are authorized to perform similar duties, the relevant provisions of the law are provided. I found this information interesting, especially some of the provisions related to expanded access to care for patients. It was good to see that California patients appear to have, in large part, the same access to pharmacist care. However, the access to care may be more prescriptive with requirements in pharmacy law and its regulation detailing out how the authority may be exercised. While it is important to learn about actions taken by other jurisdictions, I think it is also vital for us to recognize that the approach taken by one jurisdiction may not be appropriate for another. We see these types of variances in state authority quite routinely. It is incumbent upon us to ultimately determine what we believe is appropriate to recommend to the legislature as appropriate for California consumers, given our state-specific issues and our mandate for consumer protection. Where there are differences between jurisdictions, for example, in size, population, licensee population, etc., it is important to acknowledge those differences. Members, do you have any comments or questions on the information provided about the approaches taken in Washington and Idaho? Thank you. And so with that, we'll open up for public comment, starting with the public comment in Sacramento. We'll go to Webex. Tricia?
Thank you, Mr. Chair. I've opened up the Q&A panel. If any member of the public would like to comment on agenda item 5, please type comment using the field in the lower right-hand corner of your screen and submit it to all panelists, or you may simply raise your hand. We're displaying instructions and we'll give you a moment. All right, I see no request for comment. Mr. Chair, shall I close the Q&A panel?
Yes, please. Thank you.
You're welcome.
Okay, we're moving on to agenda item 6, discussion and consideration of policy questions related to standard of care in the practice of pharmacy. As we transition to discussion of policy questions, I want to highlight that the meeting materials detail out some relevant provisions of pharmacy law. As stated earlier, this is our first, but not our only opportunity to consider these and other policy questions. As I stated at the beginning, from a process standpoint, as a committee, we will discuss a question posed, then open up for public comment. At this time, I recommend that we refrain from taking any action, but look to see if we have any consensus. It is very appropriate to indicate if you believe you do not have sufficient information at this time to make a judgment on a question. If that is the case, and you have a sense of what types of information would be helpful in the future, please share your thoughts. Again, it is very appropriate to indicate if you believe you do not have sufficient information at this time. This will ensure staff can provide information at a future meeting. Following our discussion, I will open up for public comment on the question. At the conclusion of the public comment, I will circle back with members for additional comments before we proceed to the next question. To ensure all stakeholders wishing to provide comments are provided with an equal opportunity to do so, public comment will be limited to about 3 minutes each question. As we get started, I want to highlight that the discussion we're having today cannot be done in a vacuum. The discussion and whatever conclusions are ultimately reached impact practices that cross over into other areas under consideration by other committees of the board. As an example, what we ultimately decide could impact, for example, workforce challenges, which could impact the work of the Medication Error Reduction and Workforce Committee. Members, do you have any questions before we get started? Okay, great. I know that I said at the beginning that we should refrain from making recommendations. However, if the committee believes it has received sufficient information to already conclude that the standard of care is not consistent with the board's consumer protection mandate, then I'm not sure if consideration on the questions are necessary. But we will proceed today, as it seems like we're still debating on that question. So we'll start with question 1. As was shared during our last meeting, the board already uses a standard of care as part of its regulation. As an example, the law requires pharmacists to exercise corresponding responsibility, but does not explicitly state the steps that must be taken. The first question for our consideration is, does the committee believe a transition to an expanded standard of care model is consistent with the board's consumer protection mandate? I personally believe that in some instances, an expanded standard of care model could be consistent with the board's mandate. However, as we know, sometimes the devil's in the details. Keep in mind, the point of this discussion is to brainstorm and not to come to hasty conclusions. It is totally normal and reasonable for us to determine as of today we do not have a definitive answer. Members, go ahead and jump in and share your thoughts. Go ahead, Jesse.
You know, after reviewing the last meeting we had, I think it was maybe licensee member Thibault who had asked the question of whether or not we have data to support improved patient care outcomes in the standard of care models that's been adopted in some of the other states, including Idaho. And it seems at this point they don't actually have some information on it. I did actually kind of have a follow-up question for Ann. We had discussed earlier that it seems like the timeline for enforcement cases with the medical board is about 3 years from complaint to final decision. Do we have a timeline of what it is for us currently?
So typically in the enforcement committee reports, we will include different benchmarks for it. All cases are different, and the complexity of cases vary. So some cases may, be resolved quite quickly, whereas others may take 3 years. But I would say that that's probably like an exception as opposed to a rule, but we can definitely provide more detailed information about that at a future meeting.
Great, thank you. So just, I guess, wrapping up my opinion on this, it seems at this point we don't have sufficient evidence to show an improved patient care protection if we transition to a standard of care model, but I think we may need more time to figure that out if we can get more information.
Thanks, Jesse. Maria?
Hi, it's Maria Serpa. I, too, find that the more that we learn about this, the more confused I am, because we are a complex process of licensees and pharmacists and other types of licensure categories that comparing the medical board and the nursing board to our practice of pharmacy by pharmacists seems to be some apples and apples kind of comparison, although I'm not quite sure of that yet. It's the vast number of disciplinary issues that we have regarding process and location that I'm very concerned about. A lot of our regulations are about process, and it has to do with, controlled substance accountability. It has to do with where we obtain our products, the acquisitions, the cleanliness of the pharmacies, and those kinds of things that I really haven't heard how this would work, or if that would be two separate things. Would we have two different, quote unquote, standards of care? Standards of care for people and standards of care for location. So I think we have a lot more evaluation to do.
Absolutely. Any other thoughts before we open up for public comment? Okay. Tricia, would you mind opening for Webex, please?
Thank you, Mr. Chair. I'm opening up the Q&A panel. If any member of the public would like to comment on question 1, please type comment using the field in the lower right-hand corner of your screen and submit it to all panelists, or you may simply raise your hand. We'll give you a moment. And my apologies, I'm looking for my attendee list and it seems to have disappeared on me, so forgive me as I take a look for it, but I do see we do have some requests in the panel for public comment, the first being Daniel Robinson. So hold on just a moment and I'll let you know when you can unmute yourself.
Just confirming there's no public comment in Sacramento? No? Okay. All right.
All right, so Daniel Robinson, you're free to unmute yourself. And Mr. Chair, did I hear correctly that people had 3 minutes to comment?
Yeah. Yep.
Okay. All right, Daniel, you're unmuted.
Thank you, and thank you for giving me the opportunity. What is very different about pharmacy and medicine, and it was pointed out earlier that there are a lot of areas of regulation that deal with facilities, drug use control, warehousing, storage. So there's a lot of regulations that are related to that. And I'm not sure that standard of care should probably apply to those areas. What happened in 2014 was pharmacists were identified as healthcare providers in the state of California. And there really nothing substantially changed in the law that allowed the pharmacists to fully function as healthcare providers. About 43% of pharmacists practice in institutional ambulatory care settings, specialty pharmacies. So there's a large number of people who are practicing and providing direct patient care, as well as those in community pharmacies that provide direct patient care services. But what we need is flexibility to allow pharmacists to provide medication therapy and preventative healthcare services with the flexibility to have that practice evolve with the standard of care, the surrounding standard of care.
All right, our next request for comment is from Nikki Chopsky. And Nikki, I'll let you know when you can unmute yourself. All right, Nikki Chopsky, you should be able to unmute yourself. There you go, you're unmuted.
Members of the committee, this is Nikki Chopsky. I'm with the Idaho Board of Pharmacy, and I really don't, other than to just let you know that I'm here if you have questions about what the Idaho experience has been like. Can you hear me?
We can. You cut out for just a moment, and I see Daniel Robinson, you're still unmuted. I'm trying to mute you and I'm unable to. So if you could please unmute yourself for the sound quality.
I apologize. If you could just also speak a little bit louder. It's a little hard to hear in the room in Sacramento.
Okay. Nikki, can you hear us?
I can, so I'll speak up a little bit. Is that better?
Yes.
Okay. I just said my name is Nikki Chopsky. I'm the executive officer of the Idaho Board of Pharmacy. And I just wanted to let you know that I was present today in case you had any questions about the Idaho experience that we've done. And so I don't really have a comment, but I just wanted to let you know that if you have questions specifically about what Idaho has done, I'd be happy to stand for questions.
All right, and our next request for comment is from Richard Dane. Richard, you should be able to unmute yourself. There you go, you're unmuted.
Thanks for the conversation from the committee members. I do want to point out in attachment 3A, one of the articles that we provided was a paper from the Idaho board discussing patient safety outcomes. So I think that could address one of the comments made earlier, and we'll continue to look for any other resources we can provide to the committee. With regard to the comment about where standard of care might apply, I would echo Dan's comments regarding pharmacy having different, regulations and expectations for facility licensees, wholesaler licensees, pharmacist licensees. I would encourage the committee to kind of discuss and possibly most likely focus its discussion of standard of care specifically on the individual licensees for the practice of pharmacy, for the scope of practice for pharmacists, technicians, and other licensee members, and not necessarily the facility or other types of licensees. Thank you.
All right, our next request for comment is from Rita Shane. Rita, you should be able to unmute yourself. There you go, you're unmuted.
Previous comments, which I just want to underscore. My name is Rita Shane, and I'm Vice President and Chief Pharmacy Officer at Cedars-Sinai Medical Center in Los Angeles. And I think what is compelling in this discussion, and yes, the devil is in the details, is what our patients need. And I think what we shared, thanks to the board previous meeting on this subject, was the complexity of patients that we're seeing across all sites of care, and the knowledge and skills of the pharmacist to provide the care these patients need. We in our health system that manages not just inpatients but outpatients, and I'm sure I'm speaking for a number of colleagues on the call, oftentimes have to call the physician, disrupt their workflow to essentially get approval to ensure the optimal medication management that was intended, but the physicians are too busy. I mean, just the data that you've been kind enough to let me share about SB 1254 and what we were able to demonstrate in terms of preventing patient harm on med histories alone is just a simple example and has been well accepted throughout the state. So I would encourage this dialogue, and I think we can get through the details and some of the what I would call best practice, standards of practice for sterile compounding, for management of controlled substances, and still advance the care of our patients, where our data in California demonstrates that baby boomers, including myself, continue to grow, and then the need for ensuring that we leverage the knowledge and skills of the pharmacists on behalf of our patients. So I'm really excited about this and appreciate the education we're getting and the opportunity to be a part of it.
All right, the next request for comment is from Stephen Chen. And Stephen, you should be able to unmute yourself. There you go, you're unmuted.
You guys hear me okay?
You're a little soft, but we can hear you.
I'll try. This is Stephen Chen. I'm the director of the California Right Meds Collaborative. Had the pleasure of speaking to the board back in October about the statewide initiative to advance medication management services through community pharmacies. And I always hate following Rita because she says everything I was about to say, but I'll reiterate a few things. First, although states with standard of care may not have robust impact evidence, I think the published evidence regarding the impact of pharmacists providing medication management services on patient safety and health outcomes is overwhelmingly positive. I'd be happy to provide condensed summary of those studies to the board if desired. And as President O stated, the devil is in the details as to how outcomes are driven and managed. And I think for us, value-based payments are key to ensuring that patient outcomes are attained safely and efficiently. And I think Rita said it very well. The real tragedy is when pharmacists identify serious, actual, or potential drug-related problems, and they're unable to help because, as Rita had shared, trying to contact a physician, get a response to something that needs to be addressed very quickly can be an overwhelming barrier. So I really appreciate this conversation, and I hope we can move fairly efficiently in this process. Thank you.
All right, our next request for comment is from Stephen Gray. And Stephen Gray, you should be able to unmute yourself.
Yes, thank you very much. I would just like to comment, reemphasize what several have said. We need to separate the standard of care concept model for pharmacists with more of a regulatory permissive approach for facilities and for specific items such as inventory records and so forth. The other thing I want to comment on is California has actually had for pharmacists the standard of care model for decades. But I'm talking about those AmCare practices where pharmacists are managing drug therapy. Pharmacists in California have been doing that for over 30 years. And in fact, there are thousands, literally thousands of pharmacists now that are practicing their profession in California and never touch a drug. They are managing patient therapy, and they're managing the most complex therapies, the highest risk patients, and taking that over. And in fact, the board's or the sunset bill in BPC 405.2.6 is about advanced practice pharmacists. And there was a comment about, well, pharmacists have to check with the physicians. Advanced practice pharmacists can take over the management of therapy, and they don't have to get prior permission from the physicians that are taking care of that patient. According to that statute, they merely have to notify them. And if they do take over that practice, then I'm sure right now the Board of Pharmacy, if there was a complaint, would use the standard of care model in order to evaluate whether that complaint was actionable or et cetera. And that has actually been a part of the process for years in both the regular pharmacists under collaborative practice agreements, which now all pharmacists can go into if they're qualified, educated, et cetera, and for hospitals where the hospital basically can delegate the authority for total medication management for patients in the hospital. So we are already in the standard of care model. The issue is we don't want the regulatory model to delay moving forward with the additional things that pharmacists with their specialized training and experience can do for the benefit of the public. Thank you.
All right, that marks the last of our requests for public comment. Mr. Chair, shall I close the Q&A panel?
Yes, please. And we have a public comment in Sacramento. All right.
Thank you. Mark Johnston with CVS Health. Also the former executive director of the Idaho Board of Pharmacy, so same job as Nikki, who is, well, basically the same job as Nikki, who's on the line. CVS Health only has 3 pharmacies in Idaho, so I'm really not speaking from a CVS Health perspective, more of what I've seen in Idaho during my 21 years of living there and the evolution of pharmacy. First off, I think Idaho is the only state where in pharmacy they really have enacted a standard of care, and very much in its infancy there. So if California does adopt this model in full, you certainly would be on the cutting edge of this topic. But I wanted to highlight that there's a couple of portions to the standard of care as I see it. One is expanded pharmacist practice, and I think California is well on its way. Some great changes as of January 1st this year, population-based collaborative practice, expanded prescriptive authority for advanced practice pharmacists, CLIA wave testing, immunizations. I mean, so just great changes that do get you up to speed and could even be on the cutting edge of pharmacist expanded practice. But the other half that I haven't heard the board concentrate on is reducing administrative burden to give the pharmacist the time to engage in these expanded practices. And that's a key component of standard of care. You know, standard of care, the reason you would need expert witnesses to prove a standard of care is because there's not an obvious black and white violation of the law. In a rule book that's so big as California's, there's plenty black and white violations of the law. So it doesn't make sense in having a standard of care and an enormous rule book. You know, a couple of examples, when somebody's called back to the pharmacy to help out, you have to keep a log. It's a very documented log. Instead of spending time with the patients, you're filling out a log of when somebody comes back to help the pharmacist. Completely support help for the pharmacist completing the log. Inventory reconciliation reports. No other state goes to that extreme. I've never seen any study by the board to show that it's really made a difference. It really takes away from the time that pharmacists spend with patients. So what Idaho did is strip their rule book down to, I think it's less than 30 pages when the rules portion of California's book is, I don't know, over 200 pages or something. That's a key part of the standard of care. So instead of focusing on how do you discipline or how do we expand practice, I'd like to see, how do we reduce administrative burden, which is a key component I haven't seen you address. Thank you.
Thank you. Mr. Cooper? Yeah.
Good morning. I'm Bill Cover. I'm Associate Executive Director of National Association of Boards of Pharmacy. Thanks for this conversation and this committee's work. Just wanted to give some perspective. I know I presented some information at the last meeting of this committee. But again, I just wanted to update that based on the resolution from a few years ago, we continue at NEBP look to examine our model act and rules and where, as applicable, standard of care approach can be incorporated into those model rules that states can use as a guide for how they regulate within their state. But I think what Ms. Webb described is also what I hear in other states of the difference between pharmacy practice and medicine and other health professions, and the dual role of not only individual practice, but facility and drug control and the various things. So I think that's where a lot of states have really considered moving in this direction, and many states have a varying level of a bright line regulation. I think that's a very good way to put it in a legal framework. And I think that's what pharmacy and the practice is accustomed to. So I think this is a significant change, but I, as a pharmacist myself and as a former board of pharmacy member in Indiana, I think that for states that, the administrative piece of moving a prescription standard of care is significant. I think if you don't go in that direction, then it's behooving upon any of our member boards to really work to keep their regulations up to date, and I think that's the challenge of how do you keep those relevant, and what is the critical components of public health protection, and what are those things that we can set aside that are prohibiting new practice models that can impact patient care, access to care, and that delivery. So I think that's again what we always talk to our member boards about is, how do you keep those active, especially what we learned and takeaways from the COVID-19 pandemic. How can we regulate in different manners? And we're here to support as an association our member boards in any of those changes. Thank you.
Thank you so much, Mr. Kluger. Okay, thank you everyone on the comments on Webex and in person. Members, based on comments, do you have any questions or comments? Okay, we're ready to move on to the next question. So question 2, as was discussed earlier today, there is an explicit prohibition on the corporate practice of medicine. There is no similar prohibition on the corporate practice of pharmacy. The question for our consideration is, as California law does not prohibit the corporate practice of pharmacy, does the committee believe a standard of care enforcement model is possible within such framework? I find this question very challenging, especially because during our last meeting, we received public comments indicating that at least one pharmacy corporation, to reduce liability, established policies and procedure to define, at least in part, how a pharmacist would need to perform functions. Based on what I have learned and heard, I'm not convinced a standard of care enforcement model is possible while California law allows for the corporate practice of pharmacy. This is a complex issue because it is possible that a pharmacist believes the corporate policy is contrary to the standard of care. I'm unclear on how a pharmacist would reconcile this, especially when it is in their pharmacist license on the line. Unfortunately, I have seen this occur in some instances of corresponding responsibility, for example, where a corporation's policy has prevented a pharmacist from exercising corresponding responsibility. I'm not sure how to reconcile that issue. Members, thoughts? Okay. Public comment in Sacramento? Public comment, Webex, please, Tricia.
Thank you, Mr. Chair. I've opened up the Q&A panel. If any member of the public would like to comment on agenda item 6, question 2, please type comment using the field in the lower right-hand corner of the screen and submit comment to all panelists, or you may simply raise your hand. I do see that Richard Dane has his hand up, and just a reminder to please keep your comment to 3 minutes. And Richard, you should be able to unmute yourself. Yes, you're unmuted.
Thank you, President O. I think a really good discussion. I don't have much else to add other than my own personal thoughts. I kind of feel like a lot of corporate policies and procedures are currently being put in place because of the very complicated, specific regulatory framework that we currently have in place right now. I personally feel that companies have these procedures in place because they want to try to protect themselves with our various regulatory framework that's restrictive in certain cases. And moving towards a standard of care model, I think this policy discussions are a really good one to have. So thank you for bringing that up.
Thank you, Dr. Dang. Marie?
And the next request for comment is from Stephen Gray. Stephen, I'll let you know when you can unmute yourself. And Stephen Gray, you should be able to unmute yourself. There you go.
Thank you very much. I have over 35 years of experience of working with major medical groups in California, and I'm very familiar with the law that prohibits the corporation from practicing medicine. I think it's misunderstood in this context. Already, the law in California and this Board of Pharmacy will hold a pharmacist responsible for following the law, for following the standard of care, despite whatever the employer may say. And that's really the difference in the corporate practice of medicine. Physicians generally cannot be employees of a corporation, of course, unless it's a physician corporation. But there are exceptions to that rule, certainly. So it really gets down to the employee-employer relationship. And like I said, the Board of Pharmacy has already dealt for years with the fact that the PIC, for an example, in a pharmacy is obligated to meet the roles and responsibilities of a PIC, regardless of what the corporation or the employer says. So we really already have that existing, and I don't think that's a barrier. And to going to the model for the advancement of the practice and the greater service to many pharmacists in California do not have an employer. They are self-employed, and they establish their own policies and procedures. And even for them, they cannot go below what the expectations of the board are, or what under this model would be the standard of care. So we have pharmacists by definition that work inside and outside of a pharmacy or a hospital. And those, many of those are practicing their profession under their own responsibility and their own integrity. And basically, that's what we're expecting with going to the standard of care model. Thank you.
Thank you, Dr. Gray.
And I see no further requests for public comment. Mr. Chair, shall I close the Q&A panel?
Yes, please. We might have discussion. So go ahead, Maria.
Hi, this is Maria Serpa. I thank you for the public comment because it kind of sparked a concept for me. And I agree with both the speakers that the legality or the issue of corporate pharmacy may not be an issue. But I'm wondering if we should have some further discussion on a hypothetical situation. If I work for a large corporation and my standard of practice allows me to be extensive or more advanced in my care of my patients, but my company refuses me to provide those services because of their concern of liability. I think that's an interesting situation that we would have to discuss further when there's a conflict. Not the conflict of, performing more than what is beyond the standard of care, but what happens when there is a conflict on when there is a lesser provision of care based on perceived legal ramifications to the corporation. Thank you.
Great comment, Maria. Go ahead.
I personally don't really see how we can continue allowing pharmacies to be corporate owned and transition to a standard of care model. Specifically in that realm, I think maybe it is appropriate for certain other areas of practice, but a concern that I do have is that many corporations already require their pharmacists to get added certifications. So, for example, they may require their pharmacists to be certified in furnishing birth control, naloxone prescriptions, immunization services. So they're already requiring this, and I know that the standard of care model does not require pharmacists, but I think my concern is the conflicting, requirements of a corporation that may put pressure on their pharmacists to become certified. Maybe they don't feel comfortable, but maybe they do feel pressure to provide services because they're concerned with retaliation. They may be concerned that they'll lose their job. And even as we continue today to talk about working conditions, if a pharmacist is exhausted and they're at the end of a 12-hour shift, they've worked 50 hours in a week because, who knows, maybe someone got COVID, they're short-staffed, it may not be appropriate in that moment for that pharmacist to provide clinical services, but they may be worried that their employer will discipline them if they don't. So that's a major concern that I have, at least in a retail chain setting, in regards to corporate-owned pharmacies.
Thank you, Jesse. I do understand and totally hear that. Indira, I realize that we're trying to extract some policy thoughts, so I'm going to actually go around and probably just call upon to just kind of get your thoughts on each question, just so we have some material for our staff to see where we are. So go ahead, Indira.
So my comments with respect to, I guess, this question, and it probably is touched upon by some of the other questions, and it's something that Anne had raised earlier. On one hand, we are talking about the expansion of the scope of practice for pharmacists. I have not yet fully understood in the discussion or with the data that we have how that is consistent or inconsistent with our mission of consumer protection, and whether or not the standard of care, if we're talking about the standard of care in the context of being able to expand the scope of practice, that's one thing. The standard of care model with respect to consumer protection and enforcement is something different. And so I would caution us from conflating the two, and I would, as far as needing more data and discussion, I would like those two issues to be fleshed out separately or thought of separately. And I don't know if anybody agrees with that, but that, for me, as a layperson, that is something that I'm struggling with in the materials that we've been presented with.
Can I comment to that? I agree with you. I think we need more information. I think the concept is that expansion of pharmacist roles will increase consumer access to healthcare. We have many areas across California, both in urban and rural settings,
in which we have hospital deserts or areas in which patients don't have access to physicians or clinicians. And so pharmacists are often thought of as the most accessible healthcare provider. The only thing that I do want to bring to the board's attention, and I think maybe we can round out at some point, is the concept of health equity. Yes, we want patients to have access to healthcare, but we need to make sure that the facilities providing these services have the sufficient resources to provide that care and provide quality care specifically. It's not enough to just license every pharmacist and give care if those pharmacists are burnt out, if they don't have sufficient staffing or support, if they're being pulled in 1,000 directions at the same time, or if their staff isn't properly trained. So I hope that gives a little bit of perspective for you.
And so I think maybe we'll hit upon that later. I guess with that, then I think we still need more data to know whether or not the changing to a standard of care model provides that in terms of consumers, that type of protection.
I agree.
Yeah, versus some other options that might be available.
Right. Okay. Maria? No others? No? Okay. All right. Sounds good. Thank you, guys. Yeah, absolutely. Okay, so we are at it for about 2 hours, so we're going to take a quick break. We'll come back at 11 o'clock. Thank you, everyone. Welcome back. So we're going to move on to the question 3 related to the last question. Oh, yeah, and we'll take a quick roll call before we start. We'll start with Maria.
Present.
Thank you, Maria. Indira.
Public member present.
Thank you, Indira. And Jesse Crowley.
Licensee member present.
Thank you, Jesse, and I'm here. The quorum is here. We're back. So starting back at question 3, related to the last question, is does the committee believe it is appropriate to only transition to an expanded standard of care if it includes a prohibition on the corporate practice of pharmacy? Again, this is a difficult question. I believe in part based on the information I shared under the prior question. I'm not sure how feasible such a bar would be, but I think the question is an important one for us to consider. If there was already such a bar, I think many of the questions before us for consideration would be easier. But I don't think we have an answer either today, but go ahead, Maria. Or Jesse.
Yeah, I think I kind of answered this earlier. I think it would be necessary, but as you pointed out, I don't think that would really be feasible,
right,
to be honest. I mean, I don't know if we have the data, but do we know, or are we able to find out how many of our pharmacies are corporate pharmacies in California?
Yeah,
go ahead, Ann.
Yeah, so we can pull like chain versus independent if that's something that you're looking for, and we can pull by ownership type as well. So we'll make a note to provide that for the next meeting.
I think that would be useful. Thank you.
Go ahead, Maria.
I guess I'm a little confused because the corporate practice of pharmacy, is that equivalent to the corporate ownership of the physical facilities? And I think that I'm not quite sure, maybe Eileen can help me to understand that, because I think it would almost be impossible for us to look at barring corporate pharmacy because there's ownership of hundreds, if not thousands, of locations in California.
Right.
And I think what you're asking is, and that's one of the questions, is can we separate out the ownership? I think some of the other public commenters have stated, that you can have corporate ownership of an entity, and maybe something the board should consider is, do you need to have some type of flexibility in the ownership of a facility that maybe has a high, like for instance, drug volume, or is that going to result, if you abolish it, in a reduced number of pharmacies and reduced competition. I don't know, but I think you can separate out maybe the ownership from the practice of pharmacy, or at least that's something that the committee should consider. I think some of the other public commenters have also stated that, you know, we can have provisions in the law, or if the legislature stated that the clinical standard of care has to be determined by a licensee rather than, you know, the pharmacy. So I think those are all questions that warrant discussion, plus some of the other additional data points that Member Crawley had talked about as well.
So with that in mind, I think that I have a lot more questions. My brain just kind of exploded with the whole idea of, you know, are these independent consultants working for a corporate pharmacy, and how that would affect their employment contracts, and then how this would also impact labor law. It seems like all of a sudden I see lots of tentacles that would need to be fully evaluated.
Thank you, Maria. Indira?
I mean, I think it does create a lot more issues, because there's now a new step one. It's as if you can't even consider standard of care if you can't answer that first question with respect to corporate practice pharmacy. And again, still focusing on the issue of consumer protection. You know, it takes us so far away from the issue at hand with respect to the standard of care and switching to the standard of care model. It just seems like it's a completely separate, almost like a separate subcommittee.
Absolutely.
I have one other comment to make. Just in regards to, I think one of the public comments had mentioned how, you know, California law already holds the pharmacist accountable in the situations where there is a corporate-owned pharmacy. I do want to kind of think back to the previous meeting discussion in which there, I think it was the nursing board, maybe just having some disciplinary action where maybe the facility didn't meet the standard of care, but someone who's working at that facility would assume that their workplace is meeting standard of care. And that kind of gets into a tricky situation of holding the licensee accountable. And in our situation at the board, of course, we have facility licenses as well. So the concern with a corporate-owned standard of care model is that you don't necessarily guarantee that a pharmacist is dictating it. I'm sure there would probably pharmacists involved in policies. And I think there was another comment made that the restrictions and regulations are what creates policies at the corporate level. So I would be curious to see if we could gather more information from corporate pharmacies within the states that have already transitioned to standard of care, to see if they still have a similar amount of policies and procedures in addition to the standard of care model. Do we have that information?
The only thing that I can recall from the last meeting is that there was public comment from one of the public commenters that works at I think a grocery chain, I can't remember. But when Idaho, if I'm remembering correctly, transitioned to a standard of care, then the corporation developed policies and procedures as a way to reduce their, if I'm understanding correctly, I'll go back and check the record, but as a way to reduce then their liability.
Okay, so then the liability then just fell more on the licensee, is that right? Or
I don't know that I can answer that piece of it.
Yeah, I think it's as everyone's kind of alluding to, it's a very complex situation that we're going to have to think long and hard about and just get as much information as possible.
Right. Okay. Thank you, members. Public comment in Sacramento? Okay, we have one.
Hi there, Mark Johnston with CVS Health again. Again, only 3 pharmacies in Idaho, so I know from a corporate perspective, CVS hasn't changed policies for 3 stores. It's their federal policies. But I did want to talk about, some of the expanded practice that is part of a standard of care model. There was a question earlier about adding a statin to a therapy. When we were promulgating the rules initially, the Medical Society came unglued and testified over and over again how that was inappropriate. However, once the law passed, shortly thereafter, we found out that physicians appreciated pharmacists filling the gap and identifying those areas and prescribing. And, even when we called to give notification, they were too busy to take notification, and now it has become the standard of practice. Pharmacists add statins to the therapy, and physicians don't question it. I think Nikki's still on the line. She could probably tell you there's never been a complaint to a board of pharmacy about a pharmacist adding a statin to a therapy. There's never been a complaint to the board of pharmacy on a pharmacist changing a dosage to a liquid for a child when it's prescribed in a capsule, or if the 10 milligrams is unavailable, giving the 2 5-milligram tablets, or many of the adaptations that have been available for pharmacists in Idaho for more than a decade that we don't enjoy in every state, such as California. And also some of the I spoke earlier about reducing administrative burden. Using another example in California, sometimes when you have 10 pages of law, there's unintended consequences and administrative burden that comes out of it. In Idaho, it basically says we can prescribe. We do have a restriction on controlled substances right now, but there's basically no other law, and I haven't seen an issue of inappropriate prescribing in front of the board since that's been legal for several years now. In California, for example, with HIV prophylaxis, we have 10 pages of law to follow. One of the laws say you have to follow CDC guidelines. CDC guidelines mandate that you get a blood panel, but you can't order a blood panel in California if you're a pharmacist. So it's a circular trap, and you think you have an expanded pharmacist practice, and we have a great program that we can't roll out in California because the law is too burdensome, too much administrative burden. And I don't think it was intentional, but that's what happens when you have too many words in the law. Anyway, I'm sure there's many other companies in Idaho that have expanded practice. I personally shop at not at a CVS because it's not close, and I see the list of expanded practice that they have advertised, and it really has increased public safety and access in Idaho. Thank you.
Thank you. And we'll open up for Webex. Tricia?
Thank you, Mr. Chair. The Q&A panel is now available if any member of the public would like to comment on agenda item 6, question 3. You can type comment using the field in the lower right-hand corner of your screen and submit it to all panelists, or simply raise your hand. And we do have a request for comment from Dane. Richard, you should be able to unmute yourself.
Thank
You're
you.
muted.
Thank you. Hearing the conversation regarding the corporate practice of pharmacists and who's responsible, I think this also kind of bleeds into some of the work that the Workplace Conditions Committee and Med-Errors Committee will be discussing. But I would also point the committee to the recent regulations put forth by the Virginia Board of Pharmacy, and I'll read just a portion of it just for your consideration. So it does differentiate the responsibilities of the pharmacist versus the permit holder. The Virginia Board of Pharmacy says that the PIC, or the pharmacist on duty, shall control all aspects of the practice of pharmacy. Any decision overriding such control of the PIC or other pharmacists on duty shall be deemed the practice of pharmacy and may be grounds for disciplinary action against the pharmacy permit. So I think that something to look forward in terms of differentiating the different responsibilities and to be able to separate the standard of care expected of the individual pharmacist providing the care versus the expectation of the permit holder, which may be corporate owned.
Thank you, Dr. Dang. Go ahead, Maria.
Can you just clarify, you mentioned a committee that's doing workplace, what committee and what is the, this afternoon's committee, Med-Errors? Okay. It's the Medication Errors Committee. Okay, thank you.
All right, the next request for comment is from Daniel Robinson. And Daniel, you should be able to unmute yourself. There you go. You're unmuted.
I was in a thunderstorm and I lost my electricity, so I'm back.
I apologize, Dr. Robinson. Could you just speak up a little bit? Sorry.
Yes, I apologize that I was cut off earlier because of a thunderstorm that took out my power.
Oh, geez. Stay safe.
There was a comment about the barriers to providing consumer protection under standard of care, but the medical board is also a consumer protection agency, and that's the regulatory model they use for providing consumer protection. And in case of this current question of there's no reason that corporations can't define what services are being provided in a particular facility. As I drive by a medical facility, there will be a sign that says, "We do not provide emergency room services here." So you can, the facility can define what services are provided. If services are provided that are higher level services, then the standard of care would apply. But and if someone wants to work in a facility that provides more direct patient care opportunities, they have that option. But certainly a corporate entity could say, we do not provide certain services in this facility, and that happens in medicine, and it could certainly happen in pharmacy.
Thank you, Dr. Robinson.
All right, this is a moderator. I see no further requests for comment. Shall I close the Q&A panel?
Yes, please. Thank you, Tricia.
You're welcome.
Okay, with that, just circling back to our members. All right, we're gonna go to next question. Question 4. This question is this question for our consideration relates to some of the benefits expressed by public comment during our last discussion, specifically indicating that a transition to a standard of care model would expand opportunities for pharmacists to provide expanded services. While considering this question, I reflected on the information under the prior agenda item and noted that many of the authorities pharmacists perform under a standard of care model in another jurisdiction are already authorized, at least to a large degree, in California. Where the deviation appears to occur is related to if there are underlying regulations that further define the authority. For the first part of the question, does the committee believe expansion on the scope of practice for pharmacists is appropriate? I personally believe there are additional opportunities for pharmacists to play an important role in patient care and public health. On balance, while not autonomous, pharmacists already have the authority to perform expanded duties under collaborative practice agreements. Under the collaborative practice agreements, pharmacists may initiate, adjust, or discontinue drug therapy for a patient under a collaborative practice agreement with any healthcare provider with prescriptive authority. This is a very broad authority for pharmacists. I think it is possible argument to indicate that expanded authority already exists for pharmacists with these changes in collaborative practice. For the second part of the question, should the expanded scope of practice be achieved through a transition to an expanded standard of care model or through targeted amendments to pharmacy law? I think in either case, the issue of pharmacist autonomy must be resolved. Members, Maria? Sorry, this is a loaded question, so another loaded question.
Yeah, so many different things. So at the first part, I think I am intrigued and excited at the same time about the potential for better patient care by expanding the scope of practice. I think that's something that is to be considered. But I'm still very confused about if it's about the individual being able to provide some services and not others, whether that means that they have expanded training or opportunities, experience. How would that service be provided in a larger group where you have multiple pharmacists working, and then that service may not be available every day or every open hour. And that would be a concern of mine if you have a patient who, example, is being monitored for warfarin therapy, and the person and there's only one pharmacist at that location that has that ability or that desire. That makes me worried, versus the whole pharmacy or the location would do that all together such that all the pharmacists could provide that care, so that if a pharmacist is on vacation or has a day off, that the patient care continue, that it not be based on one person's practice area or one person's expertise, and how to accomplish that. So that's the first part. Of course, as mentioned by members of the public, targeted amendments to pharmacy law are extremely tricky. Very difficult to do usually even in the first round. There's always these unintended consequences, and so that is very, very difficult.
Indira?
No, don't have any further.
No comment. Okay. Jesse?
The only thing that I really have to say about this is that I don't think we can look at the extension of scope of practice as an isolated issue. I think we have to take a lot of things into account and maybe also leverage, like we said, the medication error reduction committee, kind of see what their findings are and working conditions and get a bigger picture rather than, deciding. Of course, I do support the expansion of pharmacy practice. I'm hesitant to say across the board that I think it's appropriate for everyone or every setting. I think there's a lot of factors to consider with this issue.
Thank you, Jesse. It's a tricky question. Lots of thoughts. So we'll go for public comment in Sacramento. Mark.
Thank you again, Mark Johnston with CVS Health. And, the expanded collaborative practice agreement in California is just great. I mean, the new law is fantastic. It's going to take a while to develop programs, but I really think you'll see great patient outcomes because of it. At some point in the future, I hope I'm here talking about the great programs that I've been a part of. But I did want to speak just a little bit about standard of care for facilities in corporations and individuals. So one of the keys to standard of care in Idaho was that we eliminated the PIC. And there's been other states like Maryland that's never had a PIC because, quite frankly, we thought that the PIC was the fall guy for the company. So we hold pharmacists and technicians accountable for their individual actions, but we also hold the corporations accountable for their actions. And it can become part of a standard of care. I'll use security as an example. In Idaho, we had a page rule on security. You couldn't have glass doors. You couldn't have hollow corridors. You could have glass windows right next to the door, but the door couldn't be glass. It was overly prescriptive. And so we got rid of it and put one line in that says that you have to have adequate security. What does adequate security mean? Well, it means what a standard of care model will tell you that it means. When something falls out of the standard of care, and 9 out of 10 pharmacies have a different security that didn't lead to an issue, and your security did, I mean, that is the standard of care, and that's an example of how it's used for facilities and corporations, not just for individuals that were talked about before. So, the standard of care in Idaho is holistic. It's not just for individuals. Thank you.
Thank you, Mark. Okay, Tricia, we're ready for Webex, please.
Thank you, Mr. Chair. I've opened up the Q&A panel. If any member of the public would like to comment on question number 4, please type comment using the field in the lower right-hand corner of your screen and submit it to all panelists, or simply raise your hand. We are displaying instructions. And I see we do have Richard Dane with a request for comment. So Richard, you should be able to unmute yourself.
Hi, thank you. Yeah, I appreciate President O's comments about the collaborative practice agreement structure we have in California. I agree that it is very expansive and broad. And I think that really that environment really does mimic the standard of care environment that we're discussing here. So really encourage the committee to consider that and look at that, and possibly consider for a future agenda having some speakers who are practicing under broad collaborative practice agreements to bring evidence of outcomes and benefits and risk to the committee, because then that really is, again, the standard of care model that we're talking about, but now we're talking about expanding it to the rest of the profession within the state. Thank you.
Thank you, Dr. Dang.
All right, and that is the last of requests for comment. Shall I close the Q&A panel?
Yes, please.
Okay.
Okay, we're moving on to question 5. Just wanting to confirm, no thoughts? Okay. So question 5, I'm very interested in your thoughts on this next question. Does the committee believe a standard of care model is only appropriate only in certain practice settings? My background is primarily in community pharmacy. I have previously shared some of my thoughts on possible challenges, at least in the community setting. I would appreciate thoughts about it. If the same dynamic exists in other settings, such as hospitals, my hope is that we will have more pharmacists working in clinics and in coordinated care settings in the future. Therefore, it really is a discussion of 2 separate layers, transforming current community pharmacy dynamics and transforming utilization of pharmacists in non-community pharmacy settings. So, Maria?
Thank you, and thank you for asking this question, because this is something that I'm familiar with how we've made changes over the past few decades that I've been coming to the Board of Pharmacy meetings, and that we have a stepwise approach. So going back to my statements on the previous question, my concern is about level of service provided that's not person-specific, but location-specific, such that that service would be provided at all open hours, whether that's 24 hours or 16 hours or even 10 or 8 hours, and every day that the pharmacy is open. And that's more easily accomplished and something we should consider in some facilities than in others. You list the hospitals, but there's home infusion, there's hospice. There are other practice settings where the practice of pharmacy is not pharmacist-specific. It is covered by pharmacists who are assigned a shift, and their expertise has a minimum requirement for all pharmacists, so that they provide the same advanced practice opportunities to the patients at all times. So I think we need to talk about this a little bit more.
Absolutely. Indira?
I do agree we need to talk about it a little bit more, for sure. A question I have is just with respect to limiting this model to certain practice settings or not practice settings, what that does for consistency in terms of how the standard of care would be argued in the practice settings that do have standard of care versus the ones that don't. I have questions, and a lot of this would depend on data as well. Who would have access, in terms of consumers, their access to certain, if it would affect or result in an inconsistency of services based on where somebody is living or what they have access to. So it raises those as well as, I think some of the other concerns, but those are 2 concerns that I have with respect to this question.
You want to say anything, Ann, about the feasibility of different practice setting and how that would actually work out?
So I think it's probably a little hard to project how it would work out. I think that from a practical standpoint, depending on what the policy, what the policy desires are, really this committee and our legislative mandate is really just kind of to provide a report to the legislature. So we can probably talk through potentially some of those practical implications of something, but it would be very difficult, I think, to anticipate some of that because, like I said, we're just really evaluating the higher thing, and these policy questions are really kind of intended to get us to start thinking about that, so it helps to formulate what the recommendation, what that report is going to ultimately conclude. So I think I guess I would say, and I don't mean to like oversimplify, I think anything's possible, right? It's really just, you have to just be very thoughtful and deliberate in the approach and assess for unintended consequences. So is it possible to maybe say in a hospital, pharmacists can do X, Y, and Z, and it's very generic? I think our law kind of already does that because there's already provisions for what a pharmacist can do in a hospital, right? That sometimes is maybe a little bit different. So I think that there's probably already a little bit of precedence for it. And I think that from an implementation standpoint, could it be tricky? Yes. Would it be impossible? No. I think a lot of it would really depend on what the solution looked like, and then talking it through and being being very thoughtful about the approach. I don't know if that answered your question, though, so sorry.
Thank you, Anne. Jesse?
Given that the substantial experience I have is in retail, I would definitely need to hear more input from pharmacists from a variety of settings before I could really have an opinion on this.
Thank you, Jesse. Public comment, Sacramento? For public comment in Webex.
Thank you, Mr. Chair. I've opened up the Q&A panel, and if any member of the public would like to comment on question 5, please type comment using the field in the lower right-hand corner of your screen and submit it to all panelists, or you may simply raise your hand. We do have several requests for comment, and starting with Stephen Gray. Stephen, I'll let you know when you can unmute yourself. And Stephen, you've been you should be able to unmute yourself.
Thank you very much. We are already in a situation, as Executive Officer stated, where we have different standards of practice in different settings. We actually started out with collaborative practice, if you want to call it that, in the hospital. But the difference was, in the hospital, what a pharmacist can do under 405(2.1) is determined by the hospital itself. And this was necessary because they have they have an established credentialing and privileging process that determine what pharmacists can do in a hospital. And what they can do in a pediatric hospital is going to be different from what they can do in an adult care hospital. And you have those different practice settings also. Physicians who practice in a pediatric hospital usually may not get privileged in an adult care hospital, and vice versa. Also, I want to comment on Board Member Serpa's comment. If a pharmacy decides to get into the anti-coag management business, and the standard of care requires that they have a pharmacist on call to answer those questions that come up after hours that is fully qualified, that becomes a standard of care for that service. And the current law already allows collaborative practice agreements, for an example, between groups of physicians and groups of pharmacists. But it's up to the facility to make sure that the individuals are qualified and they are given the ability to provide that service. A lot of pharmacies have limited hours for travel medicine, limited hours for contraceptive care and so forth, and don't provide those after hours. But something like anti-coag or other disease management would have to be to meet the standard of care that's already been established by AmCare Services for 20 to 30 years. They would have to provide 24/7 access for urgent cases. So we're already there with the standard of care for different types of facilities. Thank you.
All right, the next request for comment is from Daniel Robinson. And Daniel, I'll let you know. Okay, Daniel, you should be able to unmute yourself. There you go.
Thank you. I want to agree with Stephen Gray that many of the medication management services that we're providing on an appointment basis. So, we make appointments. Not everybody is available for immunizations at all times, or travel medicine. So that is certainly done by appointment. And I would strongly urge the board not to restrict standard of care to a certain practice setting. Many of the things we're talking about actually occur in a community pharmacy. And we certainly want standard of care. If people are providing immunizations, we want them to use the standard of care approach and always stay current with whatever's going on, not just doing it according to what's written in statute. Thank you.
All right, the next request for comment is from Richard Dane. Richard, you should be able to unmute yourself.
Hi,
There
thank
you go.
you. Hello. Yeah, I would agree with Steve and Dan and all the previous speakers as well. I would discourage the committee from restricting standard of care to only hospital settings. In my role as faculty at USC, I'm also the residency program director of our community-based residency training program, which has been training community pharmacists for the last 20 years to provide clinical services in the community pharmacy settings. And there's plenty of data that pharmacists are capable and able to provide these types of services in the community setting and not just the hospital setting. And so I would, encourage the committee to not restrict it to only certain practice settings because it is appropriate for the community and ambulatory care settings to have standard of care as well. And also you've seen examples of that mentioned by Stephen Chen, a previous comment through his work with his CRNC collaborative. Additionally, from the public perspective, restricting standard of care to only one certain practice setting would cause confusion and fragmentation of care, especially as transitions of care from the hospital to the community is one other aspect we have to consider when providing these types of services. Thank you.
All right, our next request for
ahead.
comment is from Stephen Chen. And Stephen, you should be able to unmute yourself. There you go.
Thank you. I just want to say I've been in part of many meetings nationally, regionally that are talking about this big struggle health systems are having when patients are released from hospitals or clinics. It's, as they say it, and as I say, it's the wild, wild west out there, right? If we don't have health system partners equipped to manage these patients where they live, they're going to bounce right back into the healthcare system and utilize resources unnecessarily. And for that reason, I think it's really important to highlight that community pharmacies are really the essential piece of that healthcare system that we haven't empowered. And I think to not include community pharmacies and as part of standard of care law would be a mistake. And so specifically in our California Right Meds Collaborative, for example, we know that with technology capability today, we have things like data platforms that can support real-time sharing of clinical information between health systems, hospitals, health plans, pharmacies, et cetera. And combined with very rigorous continuous quality improvement and value-based payments that we use in our program, we've proven, I shared the data with you, that we can drive optimal health outcomes through community pharmacies very effectively. We're also finding that by having our health plan partners equip community pharmacies with social support resources, our community pharmacists are able to connect and close the loop on essential services that are critical to patients' overall health. So I just think it would be a big mistake to not include community pharmacies within the standard of care. Thank you.
All right, that was the last request for public comment. Shall I close the Q&A panel?
Yes, please. Thank you, Tricia. Thank you for all the comments. With that, just go around to see if any members have any additional thoughts. Okay, I do think that I kind of agree with that side. Again, today is really not a day to come to any conclusion, but I do tend to hear and agree that it would be quite uncomfortable or difficult to have just certain practice settings have standard of care while other settings are not. But we will contemplate that further in subsequent discussions. So we'll move on to question 6. We're browsing through here, members. We have previously discussed the scope of practice for pharmacists and that for many authorized duties, there is regulation that further defines how a pharmacist must fulfill those duties, at least in part. The next question speaks to one way to transition to an expanded standard of care model without wholesale changes in pharmacy law. In my opinion, it is a stepping into transition. As an example, under existing law, pharmacists may provide hormonal contraception under specified conditions. As part of this question, I believe we are being asked to consider if the scope of practice related to a pharmacist's authority to provide hormonal contraception is appropriate, but the additional requirements to exercise such authority would be repealed. In hopes that example was helpful, the question specifically is, does the committee believe that specific provisions included in a pharmacist-defined scope of practice that require compliance with specific pharmacy regulation would be more appropriate to transition to a standard of care model. I believe there's an opportunity here, but not to sound like a broken record, it depends on the guardrails in place to ensure pharmacists empowered to operate under standard of practice. We also want to highlight if the pharmacist is appropriately educated or trained. Do we want to remove those objective standards to demonstrate a pharmacist's knowledge and training rather than relying on the pharmacist's assessment of her own skills and training? Members, Maria, what are your thoughts?
This is a question that I find very exciting because I think that we have historically been limited to be extremely detailed on the provisions of providing these kinds of medications, including smoking cessation and all sorts of things under et cetera. And by having standards of care apply to these types of services, it would take a lot of the details out of pharmacy regulation and revert it back to what is the standard of care and practice at the time of the situation, which is always changing and emerging. So you look at example, PrEP and, I always say it wrong, PEP and PrEP, that is something that is changing sometimes a couple times a year, and just being able to keep up with the emerging information, so we could look at what is the standard of care at the time the patient is being cared for, and being up to date would be important, and by not having that detailed in regulations would be helpful.
Thank you. Indira?
I appreciate that sentiment. Again, with sort of my more lay perspective on this, I still feel, and maybe a broken record, we're missing some data. So with respect to some of these changes that we're talking about, do we have, I assume we do, but with respect to enforcement or investigations, what percentage, if any, involves compliance within that type of setting? So standard of care seems like it could play out differently for some of the types of investigations that we have and enforcement that we have. And maybe it doesn't apply to some of the things that we're talking about here. And so I'm wondering, looking at our own data in California based historically, like what we have done, it would help me understand this better. That if we're talking about, compliance with specific pharmacy regulations, and the ones that you guys are mentioning and talking about, does that ever give rise to investigations or discipline?
And I'm wondering if we probably have jumped forward because we do have members of the public who are not familiar with the details of pharmacy, and we also have new members of the board. Maybe we could talk just a couple minutes if you could introduce what these kinds of programs are about, or I could give you my opinion, but...
Go ahead, Maria.
So there are certain provisions in the law that allow a pharmacist to provide therapies to patients with very, very specific limitations. Sometimes they'll have training requirements. You have to turn that into the board that you're trained. I'm sorry, I can't look at you and talk in the microphone at the same time. Or there are like formulas, recipes. If the patient has A, you can provide treatment A. If the patient has A and B, you can provide patient with treatment C. It is very formulaic and not a lot of judgment involved. And that's the way the regulations are written now, because of the climate of not having standard of care and the limited availability or the limited opportunity for pharmacists to practice. So going back to your question about enforcement, just in my experience, there's been two things. Because of the specific regulations and process, many pharmacists say, why bother? They don't get reimbursed for it anyway. So why bother doing this and going through all these training and all these things? So then those services are not actually being provided in the numbers that it could be. That's one thing. The other thing is those that are trained do it well. I don't think I've ever seen, except for recently about vaccines, any citations or disciplinary action regarding these, because if they go through the training and they're the high performers anyway. So that's just my opinion, but I'm sure others may have other comments.
Complex issue. For sure. Jesse, you're...
Just kind of continuing off what Maria started, from my understanding, and I really haven't been here as much, but it sounds like vaccine errors specifically has increased substantially since the pandemic began. I know pharmacists personally who have been required by their employers to administer over 100 vaccines a day with no additional staffing, sometimes less staffing, in addition to the regular workload of over 300 prescriptions. So I think looking at this issue by itself, as I said previously, really doesn't give us the full perspective of what actually happens. And I do want to point out as well, even community settings under the same chain, if you go a mile and a half over to a different store, you may have an entirely different patient demographic. So an example of myself, I am a certified point of care trainer nationally, but I have never actually practiced that, and I was certified back in 2015. So although I have the training to provide point of care testing, it wouldn't be appropriate for me to administer that today without some additional training or some personal experience. So I hope that provides some perspective. I don't think it's necessarily a black and white thing. I think a lot of these are circumstantial and situational.
I don't want to touch the hornet's nest here, but Maria did bring up reimbursement. I just want to say I think that really is a huge issue. Obviously, that may not be in our jurisdiction, but that really is a huge issue that, you know, we had SB 493 and all those years that we had expanding pharmacist scope of practice or whatever we want to say it. You know, where we are today, I think we were hoping that we would be advanced much further than where we are today. And I think without certain transformation in reimbursements, all the discussion we're having today may not be as impactful ultimately. So I know that's not our jurisdiction. I just think we wanted to point out that, you know, there's huge issues with reimbursements and the health plans, and how that's being dictated nationally probably has a huge implications on what we discussed today, how impactful actually it will be. So hopefully we'll have some update on that in the future in the positive direction. Go ahead, Ann.
So with just circling back to Indira's question about, you know, what does the data show us? I think it's a little bit hard in some respects to compare, because when we look at, and I don't think I'm talking out of turn here, when we look at a lot of our disciplinary cases, right, you're going to see a lot of them are related to failure to exercise corresponding responsibility. And I think that, you know, you hear sometimes, well, I didn't understand what that meant. And that's really an area where there's a lot of use of standard of care, right? Because the law says you have to do it, doesn't prescribe how. It's a little bit hard, though, to draw a connection then to an investigation where maybe a pharmacist, I don't know, didn't fulfill the requirements of the hormonal contraception. Like I can't recall ever seeing that before. But is that because everybody understands how to do it, or is it because the law prescribes how to do it? So I don't know that we can necessarily like draw a correlation between the two, but we can absolutely like pull some data in that area. We can pull, the misuse of education code and see like kind of what those kinds of cases look like as a way to like try to connect some of it. But I think for some of it, it's just hard to say because you can't determine what the causality of the data actually represents, if that makes sense.
Thank you, Anne.
One final comment, just kind of going off of that, as a pharmacist who is certified in many different avenues, and I have provided hormonal contraception, and I've prescribed naloxone in my practice. I actually do find these guidelines set by the board extremely useful in practice. It's very easy for me to reference these set guidelines and know that I always have that reference. So I just wanted to kind of provide that perspective.
I do agree with that. I think a lot of pharmacists I've spoken to also, I think a lot of them just kind of fall back on those guidelines that we do have in a way for their probably sense of comfort in that they follow along and that they will be able to take care of a patient. But I guess that's just, again, holistic question back to where do we want to go in terms of pharmacists' abilities and what they get to do in their practice. So lots to come. We're going to go for public comment here, and Mark is coming, so we'll give him a chance to speak.
Thank you, Mark Johnston, CVS Health. You know, a standard of care involves a certain level of trust. You know, in Idaho, we trusted the profession of pharmacy. You know, it is a profession. The overwhelming amount of us are doctors of pharmacy. And the standard of care is not developed by the board. We heard our first speaker from the Board of Medicine say it's developed by the profession. So, you know, if the board, you know, regulates that a certain practice setting can have a standard of care and another one can't, that's contrary to a standard of care model. It develops on its own. It's the profession that figures out that, hey, maybe a busy pharmacy isn't the place for expanded practice. That's born and happens itself. You know, a restriction on, you know, you have to provide the services every hour that the pharmacy is open. That's contrary to standard of care. That's not a standard of care. That's prescriptive. You don't write that. And, you know, it develops on its own to serve the public. You know, a certain amount of training is a good example. You have to have this amount of training. Well, then it changes, and the standard, it's such a standard of care that the universities are already teaching it. And then you have to come out and go through the training again anyhow, and then that's a barrier to the standard of care. So you just say appropriate training, and it bears it out. And if people start, you know, performing the function without adequate training, then the standard of care points that out, and you know, you can make that a disciplinary case. So it really is a matter of trust and letting go, and I understand how hard that is. In Idaho, we had meetings for 2 or 3 years before we really, you know, got to the point where we trusted and let it go. This is very healthy and very initial conversations, but you know, if you're really going to consider going to a standard of care model, an entirely different mindset is really what's needed, and I know how hard that is. So, thank you.
Thank you, Mark. We'll open up for Webex. Tricia?
Thank you, Mr. Chair. I've opened up the Q&A panel. If any member of the public would like to comment, please type comment using the field in the lower right-hand corner of your screen and submit it to all panelists, or simply raise your hand. And we'll go with Stephen Chen first. Stephen, you should be able to unmute yourself.
Thank you. Thank you. Great, robust discussion. I just want to share a few things addressing some of the concerns I heard. So first off, I've been integrating pharmacists with medical practices for over 3 decades. So a lot of the concerns that you brought up, I've heard many, many times. I'll share the example from our Center for Medicare and Medicaid Innovation program that we conducted a few years back, part of the Healthcare Innovation Award. This was with Ultimate Health Services. I can tell you that when we initially tried to introduce this to a health system that had zero experience working with pharmacists, there was all kinds of legal red flags, questions, et cetera. But once we got past that and we actually implemented, we had absolutely zero pushback. Physicians were thrilled that we were actually seeking patients to enroll and automatically enrolling them and just letting them know we were enrolling them, because they're seeing 35, 40 patients a day. They don't have time to optimize drug therapy, and they're being graded on their quality of care. So a huge plus. They saw it as an added layer of patient safety and medication optimization, which they couldn't get to. I'll give you one horrible example. This is kind of agnostic. I don't want to embarrass anybody, but we had baseline levels of statin utilization in diabetes patients at 42%. And just for those that don't know what that means, pretty much every diabetic patient should be on a statin. 42% is a pretty miserable number. So we were able to correct that very quickly. That's one of many examples. Our collaborative practice agreements were permission-based. So I heard the discussion about protocols being helpful, and they absolutely are. I don't disagree with that at all. I think it depends on what you're managing. So if it's something like heart failure or something where patients are never really fully controlled, but always in some kind of dynamic flux, protocols aren't always the best, and giving permissions for pharmacists, as physicians do, to utilize best evidence as it evolves is going to be very helpful and very important for those patients. And lastly, I'm going to just say a few things about our California Right Meds Collaborative. In order to sustain that program, we've targeted enrollment for each pharmacy sufficient to support at least one full-time dedicated pharmacist in tech. That we recognize that it's impossible to expect pharmacists to split time between dispensing and clinical, so that's why it's our goal. Our training is perennial. It's required by the health plans, live learning sessions and webinars, so that's how we make sure our pharmacists are up to date. And a combination of CQI, continuous quality improvement, and value-based payments ensure that our patients receive highest quality of care. Thank you.
All right, the next request for comment is from Daniel Robinson. And Daniel, you should be able to unmute yourself. There you go.
Thank you. I agree. This is just an excellent discussion. One of the problems with the statutory involvement of some of the practice guidelines that we're currently using, it creates a real limitation in terms of being able to adjust as necessary. For example, when the COVID vaccine became available and pharmacists needed to be able to provide it, we had to change the law. So rather than just having a standard of care model that says, okay, we're going to provide this vaccine based on standard of care, we actually had to go through a statutory process. Somebody commented that the guidelines have been very helpful that are available. Those guidelines can still be available on the Board of Pharmacy website. They don't have to be written into statutory language. And in terms of what nursing did back in 2016, they developed a decision-making framework, which actually asked a number of very important questions. For example, is the activity that you're planning to provide prohibited by any law? Is performing the activity consistent with evidence-based medicine? Are there practice setting policies and procedures in place that allow you to perform the activity? Do you have the necessary education, training, and safety to perform the activity? And there's many other of those questions that they're being asked to do. And if they meet all of those requirements, then they should be allowed to provide that activity based on the standard of care. So we've actually developed a model that could be used for pharmacy that I'd be more than happy to share with you. Decision-making framework that would actually sort of clarify the process, the qualifications that would be necessary, the setting requirements that would be necessary in order to provide activities without specifically detailing them in our pharmacy law. Thank you.
All right, the next request for comment is from Stephen Gray. And Stephen, you should be able to unmute yourself.
Thank you. Excellent discussion, and they're hitting all of the right points for this question. I'd like to reemphasize something that Board Member Serpa said. The problem with the detail in all of the SB 493. Remember, SB 493 was written back in 2013 and was discussed before that. So it's over almost a decade old. And politically, we had to go through a process that ended up with writing out such detailed protocols and putting them in regulation. What we've learned from that is kind of interesting. First of all, there is a barrier. Regulations actually have gotten harder to amend. They don't keep up in many cases, like with the PEP and PrEP. But it has another effect in that the detail of some of those regulations, for an example, naloxone, is more detailed than what physicians are held to. So you have a situation where the pharmacists in many organizations would have to go through much more detail, expend much more time than a physician or a nurse practitioner or a PA or other prescriber, even a dentist could do that is prescribing an opioid. For a drug, that gradually over time has been recommended several times to almost be over the counter. The same with contraceptives. Oral contraceptives have been recommended by national expert panels to be OTC for over 3 decades. And yet now we have this protocol. As a result, there are many unwanted pregnancies that have occurred because easy access to the pharmacist for the oral and other contraceptives was made more difficult because of the detailed protocol, a protocol again that is not detailed in physician regulations, nurse practitioner, certified nurse midwife regulations, etc. So it really is a barrier. Going to the standard of practice offers the flexibility and improves patient access to the care that pharmacists are uniquely trained and experienced to be able to provide in many situations. Thank you very much.
All right, and the next request for comment is from Richard Dane. Richard, you should be able to unmute yourself.
Hi, thank you. I actually echo what everyone's already said. They took the words out of my mouth, so I'll just be quick and say, the protocols and algorithms to providing clinical care that we currently have in statute is helpful, but does it belong in statute? I think that's what we're discussing. We're moving it from our statute and laws and just moving to that standard of care model. And, instead of putting the algorithm protocols with the specific instructions within statute, we can then provide it as additional guidance documents, either directly from the board or from our associations or from our schools and universities. So we will look to others within the profession to help develop these kinds of guidances and protocols and algorithms that can then be utilized as a tool by the pharmacists who are providing the services as opposed to writing it into our law. Thank you.
All right, and that's the last request for comment. Shall I close the Q&A panel?
Yes, please. Thank you, everyone, for the comments. Really appreciate it. So it is 12 o'clock. Unfortunately, we are constrained today by time, so we will probably not be able to go through all the questions. We can try to push for one more question, probably. This is a little loaded question as well, so I'm afraid we're going to probably get past. So we will adjourn today for the meeting. We're going to have future committees, so we're going to go to agenda item 7, future committee meeting dates. Our next meeting is scheduled for August 24th, 2022. I suggest that as part of the meeting, we continue our discussion on the policy questions and potentially revisit some of our discussion from today. I'd like to thank everyone for their participation and all the members for coming today. Please stay safe. The meeting is adjourned. Thank you.